We now call several cases. Yes. The defendant is Sindjin Prent Lamar. Was that you?
Yes, sir.
With Mr. West, your attorney and the state's attorney. Five faces. It's just one of those steps. See.
Yep.
Yes. Hold on, let me get them order. Just. All right, in the numerical sequence they are in, we begin with 22-397-61. And it looks as though these are all these are second amended motions to revoke probation, except we have a new case, 24 CR 1681 burglary of a building.
That's correct.
Is that right?
Yes.
Oh. So for the record again, what are we going to do?
Your Honor, this is a case where in July of this year 25, we had a revocation. You continued him on probation. In September, he was arrested and locked up in Orange County, and has since then, was it 24? 24, okay, yeah, I'm sorry, not 25. July of 24, September 25 of 24, he was locked up in Orange County, has done his time over there, pled guilty, and did 10 months state jail. What was the offense over there? Under controlled substance. And so since September of 24, he's been in custody, and we're just asking the court to give him time comparable to that. So we need to put these cases on and be done, and then we can plea out the new case concurrently with that.
Go ahead.
Your Honor, we're requesting
Before I say something, go ahead.
the 2 years on all of them, the maximum, even on the new case as well. He owes restitution in 22-39761. Restitution was ordered in the amount of $8,683.09. In 0680, there was $17,700 that was ordered. And 0681, there was $2,000 that was ordered. And 0682, there was $2,633.34 that was ordered. And in the new case, it's approximately $3,706.59.
How much was paid?
I don't believe you said
Nothing?
anything.
What's the grand total?
Where'd you go? Don't know what you.
You may need to kind of add that up, huh? Do we have if you'll give us the numbers, we'll do it.
Okay.
37. You have a calculator?
He owes
You have a calculator?
$683.
I'm sorry. Begin. In numericals
Okay.
sequence.
Around 37,000, but there's 8,683.09. And
Let's start off with 20. Is it 23 CR 680?
that's 17,700.
Yes.
Flat $17,700 and 680.
Yes, Your Honor.
681.
$2,000.
682.
$2,633.34. $2,633.34. Yes, ma'am.
And in
61.
the first one, 22-397-61. I missed that.
It's $8,683.09.
And then finally, we have a new case, correct, 24 CR 1681. Is there any restitution on that?
Yes, Your Honor. It's $3,706.59.
All right, so did you get all of that?
Yes, sir.
You're around 41,000, something like that.
18, let's see, it's 19, 21, about 32.
That would be
About 34, 34,500. Anybody have a calculator? Just add it. Can y'all add that?
Show me the numbers. I can do it.
34,000. I'm sorry, $34,000, $22, and then it's like 20.
No, it's going to be 34,000 and it's going to be a little over $34,000. I would place the number sensing state. And
I'm sending you in the running.
34,722. So these people are just out all that money. And he wants a package deal of 2 years for everything.
Well, that's the max.
Do I look at Santa Claus?
That's
You
The max you can receive, Your Honor.
maximum receipt.
you got a new case.
That 2 years on that as well. I mean,
I can stack them. That one and the others. I think the people would want to know why not. Right? He hadn't paid a dime, and so he wants a package on this. He can commit all these offenses, but all these offenses, doesn't have to pay back any loss, and he packages them. The question is, what message do we send? The message that we're sending here is, if you're going to commit a crime, commit a bunch of them. Commit a bunch of them, and you get them all wrapped up in one little package.
I mean, the
If you get caught, and if you're held accountable, 6 is equivalent to 1.
well, Your Honor,
Isn't that the message?
Well,
Isn't that the message? Do you think that people think that's amusing? I don't think victims do.
The other option is continue him on probation and see if you can make some payments between now and whatever set time in the future. And
Here's what I'm planning to do. Here's what I want to do. All these burglaries on these motions, we'll put all that together. And 2 years on all of that to run concurrently. The other one, I'm putting him back on probation on the last one. And so he can pay $34,000, 722 to these people. And that would be a case where he starts probation and hopefully he can do well. And if he doesn't, then this is a state jail felony, 2 over 5. And it runs with the probate, with the restitution. It's only right and fair. I don't understand we're not going to give a message. The more crimes you commit, the less you're held accountable. That defies logic. The people don't think that's reasonable. And y'all can do whatever you want, but I'm not going to. If y'all are going to do this, if you don't want to do it, we'll just deal with it separately and we'll hold a hearing on it. And then I guess these sentences can be stacked, can't they?
then not the revocations, they have to be all run concurrently because they've pled that way, but the new case can be stacked on top, yes.
It's only the right thing to do.
Was that for an official formal hearing then, or
What do you want to do?
Well,
Yeah, it's y'all's choice.
I don't know I don't think the state's offering probation on the new one. That's the problem. So I can't.
he hasn't paid anything since 2023 on that, Your Honor. I don't see where he's somehow gonna then start paying on any other case.
I know, but that's why we put him on probation for this other one. If he fails, he can go to prison. He can go to jail for another 2 years. It won't be stacked. It would run consecutive to these other things. If he does fine, he's fine. It pays it back. But if he doesn't, that you gotta have some hammer over it, and you can do it. You can do an additional 2 years on this last one. That's if you fail, but it's the right thing to do. You got to pay these people back. You just can't come in and I'll just I'm not gonna be the poster child for that. If you're gonna commit one crime, commit six and we package them together, you have to be held accountable for each crime. Each person has a victim. Each person was a victim. Each person has their own worth and value and loss. You don't treat people like that. Like they're cattle by the dozens. That's not right. I'm not gonna stand for that. What do you want to do? That's what we'll do. So, we'll get this
I
thing.
think we need to set it for a hearing next. I don't know if the state's going to agree to that, so we would, but I don't think the state would. So I think we just need to set it for.
What's wrong with the state's plan on that? You were gonna put it all together, weren't you?
Just, well, we'll just, I mean, on the other one, Your Honor, if you want to, we'll, just end up trying it, I guess.
Why would we do that? Well, why not?
Because that can be stacked as well.
Why not? How else are we gonna get money back for these people?
Well, I mean, I talked with the victims on these and they explained that you ain't gonna get blood out of a turnip and
Maybe.
this individual is gonna cost the county more money by placing him on probation and continuing to.
No, I thought the probationers paid for the fees. That's the way it's supposed to work. That's why the taxpayers don't get them.
How much is it?
They have to pay fees. And if he doesn't pay his fees and he could, then he gets revoked and goes 2 years.
I think we just set it for a hearing and let you make the decision. That way the states, they can stay with their position.
A hearing on what, John? The whole thing?
Yeah. On the revocation. I mean, if they're not wanting to offer probation for that, if they're not offering it, then we can't accept it. But we can ask you for it.
So nothing's been done today. I don't understand. I don't understand that. I mean, what's the state's plan?
Well, Your Honor, I'm confused. $0 on the probation amount.
That's why he gets revoked, and we're going to add all of these to this new case and see what happens if he doesn't come through. Then he's got another 2 years.
He committed this new case while he was on probation.
Yes, sir.
For the other, and I feel like he's going to do the exact same thing when he gets on.
Well, then
probation.
it would be it would run separately. It's not going to run concurrently with the others. It stands alone. He either rises or falls on his performance. And if he fails, then he gets another 2 years stacked on top of this collection of 2 years on this other one. That was y'all had made that deal. That's what y'all are running that concurrent. What I'm trying to do is it's a win-win for everybody if he pays back. If he doesn't, then it's still a win-win for the state. If he fails, come back and it could be revoked and he could be sentenced to an additional 2 years if you don't pay. But it's a way for the people to get paid back.
I think, Your Honor, another option we have is that he can plead true to this revocation date. You can revoke him. That's completely on your terms completely. And then we can plead open to the new one. And that takes the state out of it completely. That way they don't have to, they can make an argument with.
But I don't
It's up to you.
understand I don't understand why this doesn't make sense to the state to give the people opportunity. I mean, the probation or it sounds like y'all resolved that as he's going to get revoked and he's going to serve 2 years. But then all of that $34,722, that's lost. That goes down the toilet. But that's not what I want. We add this, we apply it to the new case and give him a chance to pay back. If he fails, then he will get another 2 years. He could be subject to another 2 years state jail. And I think he's tired of staying in jail. Man, I think he might be motivated to do something here.
Yes, sir.
That helps you and the people. Well, I don't understand why not. That thing. I mean, isn't that a win-win for y'all? He'll pick up a fifth conviction, and he does his time. He goes back and tries to pay back. If he fails, then he's back before me, and I think he gets a sense of my feeling about all of this. I expect you to work and pay these people back, sir.
Yeah.
What do you think?
What's it? I use that thing to do that. That's you. I will play up and sign. She got it.
Your Honor, if I can get a second to do the paperwork, I can get that done.
Okay. Alvin Lawrence, is that you?
Yes, sir.
25 CR 852?
Judge, he's electing to set his case for trial.
Who is the person who is the victim here? Girlfriend?
Ex-girlfriend.
Okay. Have y'all talked to her at all? Has the state talked to the
Yes, sir.
victim lately?
Yes, sir.
Okay. Because I've done this long enough. I know what's.
She's not cooperating, so I'm gonna prove this up without her.
Okay, okay. I find out you've communicated with the victim. I'll do what we did yesterday, put you in jail like we did the other person. The rules are you do not communicate, nor anyone on your behalf communicate with the victim. I know what goes on a lot of times. People don't follow the rules. That's why they're in this court for the most part. But one of the rules they really abuse is trying to get with the victims to change their stories, which would be inappropriate.
So that the court is aware. I've known about the victims not wanting to
just wanna find-
cooperate. He's got
Just let
a,
me know if you can prove something, and we'll bring him up here and we'll deal with it so that your head would spin.
I want to cover the offer on the record if I could, Judge.
Court does not tolerate the
Specific,
rules not being followed. You cannot try to intimidate or change the victim asked for this, and then later on, people try to make them feel guilty, which is backwards. And it is a criminal offense for you to try to influence this person in any way. And I just wouldn't, I would welcome the presentment of any proof and get him back here as soon as possible so we could deal with that, like we dealt with the man that's in prison now for what he did the other day, trying to influence the victim, his girlfriend, in that trial.
this man is not eligible for probation from a jury as a felony conviction. I've offered him probation in an attempt to try to resolve it. If, when we get to trial, that will not be offered. He will only be looking at either winning or going to prison.
And we have had conversations about that, Judge. He's aware of that.
Okay, well then, the deal's off.
Yes, sir.
He had a chance. He's had his chance. Be quiet. I'm speaking. Thank you, sir. You had your chance, and we're gonna go to trial, and the victim cases have been proven without a victim being present. And it gets out during the trial what's happening and why the victim is not present, and the juries understand. And they have a history of making certain kinds of decisions. They don't find that amusing at all. So it's deals off. There's no deal. Set it for trial. It will be set for trial. And that is that. Next is
Chief.
Alvin Lawrence. Yeah, that's you.
If I may make an oral request, he is on an ankle monitor. If I could request to have that taken off. That would-
State objects.
Tia Ballard was next. Get her resetting for trial. Do you have another one? Is that in? Yes. James Pageant,
Haven't seen him yet, so.
have you talked to your attorney today?
Texted him, he has not replied. I just texted him when I got here, when I told him he wasn't here.
Okay, well, we're gonna have to reset it. I mean, he should be here, and
Yeah,
that's too bad. You waste a lot of time.
yes, sir.
The court could have had another case that we would have dealt with, but he hadn't called us or anything.
I'm about to say, would you like me to call him to see how?
No, but that's not the way it works. He should be here, and actually, in most courts, lawyers get sanctioned for not being here on time, or at least calling and alerting us, because that's not the way it should be.
Yes,
I'm gonna reset this
yes, sir.
for week after next. Sorry that your time was wasted.
Okay, sorry to you.
We have it's a bond hearing.
Sir, I filed a motion requested bond.
Read 'em out, please. Thank you. 15-23549 is gonna look.
Good.
On the state on this, what are y'all doing on the cocaine allegation that was tested positive? Are y'all gonna do
I think
something?
they're still waiting on the lab on that one.
The new alleged.
We've got two cases, we've got two different dates of problems, don't we?
Yes, sir.
You're Lawrence, you're Calvin Lawrence, you're charged here in a motion to revoke probation that was filed on September 29th of this year, which alleges that you were on probation a long time too,
Yes, sir.
that you committed the offense of illegal possession of a controlled substance on or about June 18th, 2025. And you failed to immediately report to your probation office your arrest on that you were required to do as a condition of probation. And then finally, a urine sample of yours was tested on or about April 29th of 2025, which is 2 months before you are alleged to have committed the illegal possession of controlled substance. And on April 29th, your urine was tested at the probation office, I guess,
Yes, sir.
and it tested positive for cocaine, which is a violation of your probation. Let's see.
And alcohol as well, Your Honor, on that day.
And why only do one wrong thing when you can do two? What she kind of do is I'm looking at the probable cause affidavit on this June 18th, 25. All right.
Yes, Your Honor. We are requesting a bond for Mr. Lewis. He is on deferred adjudicated probation. Essentially, he's been doing well for 9.5 years of the 10-year probation. He did express, he did relapse earlier this year, in which I believe he did express that to his probation officer prior to him taking the drug test, in which he made them aware that he would be positive and was seeking some help. Mr. Lewis, prior to these relapses, had done exceptionally well to complete everything that was required of him. He was actually running a halfway house, sober living home for several years, Your Honor, and actually ran managed the cafe here at the courthouse downstairs for several years. Your Honor, we're just asking that while this motion is pending and while we're awaiting any results of this new alleged offense, that he be granted a bond along with any conditions that the court may deem necessary, such as a drug patch, things of that nature, while the motion is pending, so that we can hopefully get his case disposed of soon.
What's that say?
Yes.
And I believe he just also, what was that?
So
On September 25th, Your Honor, he also tested positive for cocaine as well.
That's on July 24th as well. Is that different from what's involved? Yes. Mr. after that.
You're gonna add, or you're gonna add? that
Yes,
to it?
yes, Your Honor. Yes, sir.
Yes, sir.
So we've got two other events.
I believe there was another offense, like from July 24th, 2025, of possession of controlled substance.
Well, no, the judge can give us straight jury.
Anything else?
No, Your Honor.
What can we be ready for a motion hearing on this?
We could be ready on we're still waiting on the labs on the possession of controlled substance, but we can be ready on the others pretty much anytime. Where he tested positive for alcohol, cocaine, and then they failed to report the new arrest.
3 weeks?
Yes, sir.
3 weeks? Let's have a hearing. You're not gonna wait long. I'm gonna rule on this.
Judges, he's not entitled to a bond based on the type of probation that he's on.
Is that right?
Deferred.
Say that again?
I believe he's on deferred adjudicated probation. I believe he is entitled to a bond.
Yeah, I know that. I thought you said he wasn't entitled to it.
Oh, no. That's it.
Yeah, $50,000
Okay.
plus drug patch. But this won't, we're gonna have a hearing in 3 weeks and it'll conclude all of this. One way or the other. Y'all can get the motion amended so that we give the defense all the information. Very disappointed. I thought we were gonna be successful on this. I'm very disappointed. This is you're looking at 20 years in prison. You understand?
Yes,